Welcome to EUPrivacyForAll, Session 28 on GDPR, Article 34, Communication of Data Breaches to Data Subjects. Communication of a personal data breach to the data subject is provided in Article 34. This article sets forth that when the personal data breach is likely to result in a high risk to the rights and freedoms of natural persons, the controller shall communicate the personal data breach to the data subject without undue delay. The communication to the data subject shall describe in clear and plain language the nature of the personal data breach and contain at least the information and the recommendations provided in Article 33, that is to say, name and contact details of the data protection officer or contact point, the likely consequences of the breach, and the measures taken to mitigate the consequences and adverse effects of this breach. The communication to data subject shall not be required if one of the following cases applies. First, the controller would have implemented appropriate technical and organizational protection measures, making, for instance, the data unintelligible. Second, the controller would have been taking measures ensuring that the high risk to the rights and freedoms of data subject is no longer likely to materialize. Or finally, it would involve disproportionate effort to have such a communication put in place. In such a case, there shall be instead a public communication or similar measure whereby the data subjects would be informed in an equally effective manner. And finally, if the controller has not already communicated the personal data breach to the data subject, the supervisory authority, having considered the likelihood of the breach resulting in a high risk, may require the controller to do so. Recital 86 of the GDPR states that the controller should communicate to the data subject wherever it is likely that the breach would result in a high risk for the rights and freedoms of natural persons. This communication should describe the nature of the personal data breach as well as recommendations for the natural person concerned to mitigate potential adverse effects. As already reminded in Session 27 on the notification of data breaches, Recital 87 and 88 frame the obligation of the controller in case of breach and define in Article 4.12 what a personal data breach is. Article 42I also reminds that codes of conduct could be framing not only data breaches notification to supervisory authority, but also communication of such breaches to data subjects. Article 58.2e also encompasses a provision regarding each supervisory authority having the investigative powers to order the controller to communicate a personal data breach to data subjects. And finally, EDPB, in Article 71, could issue guidelines, recommendations, and best practices on how to establish a breach and how to communicate it to natural persons. The Directive 95/46 does not include any kind of specific framing of communication to data subjects regarding data breaches, but Articles 10 and 11 refer to any further information that should be provided to the data subjects, insofar as such further information is necessary, having regard to the specific circumstances in which the data are collected, to guarantee fair processing in respect of the data subject. It could include communication of data breaches to data subject. What should accountable data controllers and processors get prepared for? First, controllers will have, without undue delay after becoming aware of the breach, communicate the personal data breach to the data subject whenever the personal data breach is likely to result in a high risk for the rights and freedoms of natural persons. Controllers will also have to describe in clear and plain language the nature of the breach, providing at least the name and contact details of the data protection officer or contact point, the likely consequences of the breach, the measures taken to mitigate the consequences and adverse effects, and communication to the data subject shall not be required if the controller has implemented from the outset appropriate technical and organizational protection measures, or has ensured that the high risk for the rights and freedoms of data subject is no longer likely to materialize, or, last case, whenever it constitutes a disproportionate effort, and public communication, being equally effective, should be taken instead. The use of codes of conduct on data breaches is also possible in order to demonstrate accountability. And finally, controllers and processors should anticipate data protection authorities' orders on the obligation to communicate breaches to data subjects. As previously reminded, EDPD guidelines, recommendations, and best practices on what constitutes a high risk could be really interesting, and the notion of undue delay and disproportionate efforts deserve to be clarified.